Hello everyone. Before we start this presentation, please make sure your audio volume is properly adjusted. So when you know you can hear us clearly, please click on the hand icon on the control panel on the upper right side of your screen. Good, so it looks like you can hear me. If you're experiencing any audio difficulties, please refer to the audio pane also located on the upper right side of your screen. As an audio option, you also may select phone call. Dial instructions will then pop up and you can follow the presentation through your phone. So we're just going to wait 1 or 2 minutes to allow everyone to join, and then we will begin the broadcast itself. So please just hold on for 1 moment. Hello everyone, and welcome to our webinar. My name is Glenn Kaus, and I'm the editor of Benefits Canada. I will be your host. For today's webinar, a pop primer for plan sponsors with Kim Ozubko of Miller Thomson LLP. With the legalization of recreational marijuana coming fast, this is certainly an area many employers and plan sponsors have a lot of questions about. During the main presentation, you can write your questions to Kim by typing them into the questions pane located in the control panel at the upper right side of your screen. At the end of the presentation, Kim will be addressing some of your questions. So let me introduce our presenter today, Kim Ozubko, a partner at Miller Thomson LLP. Kim practices in the area of pensions and benefits. She has 20 years of experience and regularly speaks and writes about pension and benefits matters. So I'm now going to pass the presentation over to Kim, and she will take you through today's presentation. Kim?
Thanks very much, Glenn, and thank you all for joining us for today's webinar. As mentioned, I'm going to spend the next 30 minutes or so addressing the coverage of medical marijuana under health and welfare benefit plans in Canada. As I suspect we all know, and as Glenn mentioned in his introductory remarks, the use of recreational marijuana in our country will soon be legal. And while the pending legalization of recreational marijuana does not have a direct impact on the legalization or the use of medical marijuana, I think it's safe to say has at the very least given rise to an increased interest in medical marijuana, and at the very least has led to an increase in conversations about the drug. As a bit of a tangent, in case you were wondering, according to the latest media reports, it is highly unlikely that recreational marijuana will be legal on Canada Day on July 1st, as was initially suggested last year. As I understand it, the Canadian Federal Parliament and the Senate are still debating some of the details of the implementing legislation, with the latest speculation being that recreational marijuana will be legal sometime this summer or perhaps late this summer. With that as background, I've set out on the slide before you a brief agenda of what I hope to cover in the next 25 to 30 minutes. I thought I would begin today's session with a discussion of the current regulatory regime governing access to medical marijuana and a brief review of the history of how we got to where we are today. I then want to highlight some statistics which show a really significant increase in the use of medical marijuana by Canadians. And then we'll highlight some recent changes in benefit plan coverage of medical marijuana by several major Canadian insurance companies and plan sponsors as well. Being a lawyer, I cannot give a presentation without talking about some cases, some decisions from our courts or boards of arbitration. So I will discuss 3 Canadian cases which have been issued over the last couple of years and address the issue of coverage of medical marijuana under benefit plans. And finally, to end the presentation this morning, I'm going to discuss really briefly some thoughts on considerations for plan sponsors going forward. A caveat before we begin, this webinar is not intended to be a comprehensive review of the many issues surrounding medical marijuana, but really a high-level review of some key developments across our country as they apply to benefit plan coverage of the drug. As I'm sure you know, there are a whole host of issues that employers certainly face dealing with medical marijuana, including the use of medical marijuana in the workplace. In the interest of time, we will not be addressing those issues today. Sorry, just trying to advance the slide. I seem to have lost the ability to advance the slide. So if Glenn or some of the IT folks can help me on, that would be great. I've lost the cursor. There we go. Perfect. Thank you so much. We'll get it eventually. There we go. So again, I thought I would start with a brief history of the regulation of medical marijuana in Canada, a history that I think will surprise most people and certainly surprised me when I was doing my research for this webinar. Way back in 1999, the Canadian federal government first allowed individuals to legally access dried marijuana for medical purposes. And that access was available to certain exemptions under the Federal Controlled Drugs and Substances Act, and in particular, a section of that act that allowed the Federal Minister of Health to grant an exemption from the application of that act if it was considered in the public interest to do so or necessary for medical purposes. So in other words, an individual in Canada could access medical marijuana, but that access was dependent on the discretion of the Minister of Health. As you can imagine, this system didn't make it very easy for individuals to access the drug. It was certainly challenging. And this access, or lack of access, perhaps is a better way to describe it, was challenged in our courts. In 2000, the Ontario Court of Appeal found that individuals in Canada with a medical need have a constitutional right to possess cannabis for medical purposes, and which by requiring ministerial approval for use of the drug, the system at the time was not providing. This decision led in 2001 to the implementation of the Marijuana Medical Access Regulations, the MMAR, which you'll see I've cited on the slide before you. For some reason, I have yet to determine the federal government spells marijuana with an H. So you'll see in a couple of instances in this presentation, marijuana spelled with an H. I am not aware of any other organization that spells it that way, but it's on the slide there for you. In 2001, as mentioned, MMAR came into force. The MMAR set out a framework which allowed individuals with the appropriate authorization from a medical practitioner to access marijuana for medical purposes. Under that particular set of regulations, individuals could access dried marijuana for medical purposes in a number of ways. They could produce their own plants, they could designate someone to produce the plants for them, or they could purchase a Health Canada supply. The MMAR regulations were the only applicable regulations in force until 2013, when the guidelines for access to medical marijuana were revised, and we have a new set of regulations, and those are set out on the slide before you as well, the Marijuana for Medical Purposes regulations, or the MMPR. The MMPR made a number of changes to the MMAR, including permitting the establishment of a commercial industry to grow and distribute dried cannabis, again, just dried cannabis for medical purposes. But at the same time, it added some restrictions. It stopped granting authorizations for individuals to grow cannabis for their own medical purposes. These regulations were not without controversy. A number of successful constitutional challenges were brought in respect of these regulations on the ground that a number of the provisions were a violation of our Canadian Charter of Rights and Freedoms. Interestingly, these include challenging the restriction on access to only dried cannabis, as well as the requirement that cannabis must be obtained only from licensed producers, in which it was successfully argued denied individuals reasonable access to the drug. So in response to these court challenges, a couple of years later, in 2016, we have what we have now, and that is the Access to Cannabis for Medical Purposes regulations. These regulations repealed and replaced both the MMPR and MMAR, and as mentioned, they are the regulations currently in force. Just wanted to highlight some of the key provisions in these regulations so you know where we stand today. So under the ACMPR, individuals with a medical need and who have the authorization of their healthcare practitioner can now access medical marijuana in 3 ways: by registering with licensed producers, by registering with Health Canada to produce a limited amount for their own medical purposes, or by designating someone else to produce the drug for them. Under either option, and this is an important change from the prior regulations, individuals can use fresh or dried medical marijuana, or can also use it in the form of cannabis oil. There are limits on the amount of medical marijuana an individual can possess. The possession limit is the lesser of a 30-day supply, or 150 grams of dried marijuana, or the equivalent form if an individual is using another form. One of the key restrictions, and these were some of the restrictions under the prior regulations as well, is that an individual must first get a medical document from an authorized healthcare practitioner in order to access the drug. Really important to note that although the medical document is very similar to a prescription, it is not a prescription. As the last bullet point on the slide before you indicates, medical marijuana is not regulated as a pharmaceutical or as a drug in Canada. It has not been assigned a drug identification number by Health Canada, or a DIN, as it is more commonly known. For those of you not familiar with the concept of a drug identification number or a DIN, that number simply confirms that a product has been evaluated and approved for sale in Canada. It identifies a number of features, including the manufacturer, brand name, ingredients, strength, and so forth. From what I understand in the industry, it's my understanding that a lack of a drug identification number or a DIN continues to be a deterrent to many doctors who may be asked to prescribe the drug, and as we'll discuss later in the webinar, has absolutely created some challenges for benefit plan sponsors and members. Turning now to some statistics. Are Canadians really using medical marijuana? In short, yes. I've cited a couple of statistics on the slide before you, and the numbers really do tell the story. According to information from Health Canada, at the end of April of last year, just under 175,000 total clients, total individuals registered with licensed producers. By the end of December of last year, that number was almost 270,000, and I would expect that number has increased even more this year. When you go back further, so when you go back beyond 2017, the significance of the increase really is stunning. For example, at the end of 2016, that number was only 130,000, and in mid-24, it was a mere 8,000. So you'll see a significant increase in the number of medical marijuana users in Canada. We've also seen an increase in the number of licensed producers. No doubt some of this has to do in part to the pending legalization of recreational marijuana, but I just wanted to pass these statistics by you as well. As the slide indicates, according to Stats Canada, the number of licensed cannabis producers doubled in the last half of 2017. And to expand on that statistics even further, at the start of 2013, there were only 2 licensed producers of cannabis in Canada. Last month, there were 57 in Ontario alone. So a really, really significant increase in the number of users and the number of producers as well. So what can we take from these numbers? Does it have any impact on benefit plan sponsors? And I think the answer is yes. I think it's safe to say that with more and more users of medical marijuana, more and more employers and plan sponsors, if they have not already, will be faced with a claim for coverage of medical marijuana under their health and welfare plans sooner rather than later. So it's important that employers and plan sponsors start thinking about plan coverage and whether or not plans cover or should cover medical marijuana. As the slide before you indicates, currently most standard health and welfare plans do not cover medical marijuana or cannabis, subject to one important caveat. Medical marijuana with an H is considered an eligible medical expense by the Canada Revenue Agency. And what this means is that there are no income tax barriers to private health services plans covering the drug. It means also that medical marijuana is an eligible expense under private health services plans or healthcare spending accounts. So in other words, if you provide your employees with a healthcare spending account, provided the employees meet the conditions for use of the drug, they can use their healthcare spending account dollars towards the cost of the drug. Certainly, it's been my experience that many employers do not provide their employers, or many plan sponsors do not provide their employees with healthcare spending accounts. And in the more traditional health and welfare plan, coverage of medical marijuana has been more limited and may be a bit more difficult to provide. In recent months, though, we have seen some expansion of coverage, some steps from large Canadian insurance companies moving towards covering medical marijuana, and subject to defined limits, some plan sponsors taking similar steps as well. I want to spend the next couple of minutes discussing some of these examples, so if you are a plan sponsor and you are thinking about adding coverage, you may want to consider these coverage options that have been adopted by some companies in Canada. In terms of movement from the Canadian insurance industry, as the slide indicates, earlier this year, Sun Life announced that it was adding medical marijuana coverage as an option under the benefit plans that it provides. Under Sun Life's new policy, which went into effect on March 1st, companies are now able to choose to add medical marijuana coverage to their plans, subject to annual maximums, and those annual maximums range from $1,500 to $6,000 Canadian dollars. Coverage is only available for certain medical conditions as well, that is cancer, multiple sclerosis or MS, rheumatoid arthritis, HIV/AIDS, and as well for patients requiring palliative care. In terms of the other Canadian insurance companies, Manulife has publicly stated that it offers coverage for medical marijuana on a selective basis, and Great West Life has indicated that it plans to expand its medical marijuana coverage options in its traditional group benefits plans this year. As the slide indicates, a number of plan sponsors have also chosen recently to include coverage for the drug under their particular benefit plans. I've just cited a couple of examples on the slide before you. So for example, in March of 2015, a University of Waterloo student who was covered by Waterloo's Student Health Plan petitioned the University Student Union, who was the sponsor of that plan, to ask Sun Life to make an exception under the particular benefit plan to fund the costs of his medical marijuana. According to reports on this individual's claim, the student had exhausted other medications to ease what he experienced, which were chronic headaches, and when he submitted his medical marijuana expenses under the plan, his claim was denied. He then, as mentioned, petitioned the student union, presented an argument as to why his expense should be covered, and the student union agreed with his petition and requested that Sun Life make an exception, which it did. Again, this was before the 2018 announcement, which Sun Life had made in terms of offering medical marijuana as a benefit option. More recently, you'll see a couple of other examples on the slide. In 2017, Shoppers Drug Mart Loblaws announced that it would begin providing workers with limited coverage for medical marijuana. The cap is fairly low, it's $1,500 per year, and at this point, coverage is only available for a couple of conditions: for workers suffering from chemotherapy-related nausea and vomiting, or spasticity and neuropathic pain associated with MS. Also in 2017, OPSU, the Ontario Public Service Employees Union, introduced a plan allowing OPSU employees, their spouses, and dependents to claim up to $3,000 annually for medical marijuana. There are, of course, other examples. Perhaps some of you on the line have added coverage to your plans as well. I just wanted to mention these particular examples to show that we are seeing more coverage of medical marijuana. I think it is definitely an incremental or a baby steps approach, but as more and more companies choose to provide some coverage for the drug, and particularly if the media continues to report on the expansion of coverage, employers and sponsors who do not currently provide coverage for medical marijuana should expect their employees to start asking about coverage and potentially pushing for extended coverage. I want to turn now to discuss a few recent cases in which the issue of coverage for medical marijuana was considered. Two main categories of cases that I want to address: coverage in the unionized sector and the impact of collective agreements on the decision of whether or not to provide coverage for medical marijuana, and the coverage of medical marijuana as a human rights issue and whether the denial of coverage is a form of discrimination. Starting first with the labor arbitration cases. The first case I wanted to discuss is the Corporation of the City of Hamilton and Hamilton Professional Firefighters Association. In this particular case, the arbitrator considered whether the griever's claim for reimbursement of the cost of his medical marijuana, which had been prescribed to his spouse, was covered under the particular benefits plan. The facts of this case were as follows. The griever had submitted a claim to the insurance company, in this case which was Manulife, under the city's benefits plan. His claim was denied on the grounds that medical marijuana does not have a drug identification number or a DIN, and only drugs with a DIN were covered under the plan. He had done everything he had to in terms of submitting the claim. He had attached a receipt from a licensed producer of medical marijuana, as well as a medical document, not a prescription, completed by a doctor. The arbitrator, in determining whether the medical marijuana should have been covered, reviewed the terms of the applicable collective agreement. And I just wanted to review those terms for you. So if you are in a unionized environment, you have a sense of what terms you may want to look for in your collective agreement if it's not entirely clear whether medical marijuana is covered. Two key sections of the collective agreement: the coverage description provisions of the agreement, which provided that the employer shall pay the full cost of the premiums of the extended medical plan, including semi-private coverage and drugs for all employees. Interestingly, as you'll note, there was no express reference in the coverage description provisions of the agreement to indicate that only entitlement to benefits would be provided only to drugs which had been assigned a drug identification number. There was, however, such a restriction in the section on claiming benefits. That section provided that drug claims must indicate the prescription number, name, strength, and quantity of the drug, plus the drug identification number. It also defined the covered drugs as drugs purchased on the prescription of a medical doctor. The union, in presenting its case, argued that the reference to a DIN in the claiming benefits section of the agreement was procedural. It was administrative in nature only and did not mean that only drugs which had a DIN were covered under the plan. The arbitrator rejected that argument. He found on the whole that the collective agreement only required coverage for drugs purchased on the prescription of a medical doctor and that had a DIN. In the arbitrator's view, that requirement was not simply procedural in nature. It was a mandatory element of any claim and acted as verification that the drug for which coverage was being sought was an approved drug. The arbitrator quite simply went on to find that a fair and straightforward reading of the relevant provisions of the agreement suggested that the parties only intended that the extended health plan benefit coverage would apply to drugs with DINs. Because medical marijuana does not have a DIN and because the griever had not submitted a prescription, under the terms of the collective agreement, the griever was not entitled to reimbursement of the costs of his spouse's medical marijuana. The second case I wanted to address is also an arbitration case, and that is the case of CIBC versus United Steelworkers. Again, in this particular case, the griever had submitted a claim for medical marijuana. That claim was denied on very familiar grounds that only drugs with a DIN are eligible for coverage under the particular plan. The griever argued that the denial was a violation of the collective agreement, and in the case it shows the employer as being very sympathetic to the griever. The employer appreciated that the griever's symptoms were improved with medical marijuana, but it argued that the health plan simply did not cover all drugs and that the scope of the coverage was defined by the requirement that a drug have a DIN. The employer also argued that the arbitrator had no jurisdiction to continue the grievance on its merits. The arbitrator agreed and dismissed the griever's claim. He found that the issue of drug plan coverage was not addressed under the collective agreement in question and was quite simply outside of his jurisdiction. In reaching his decision, though, he made a number of comments, and again, I want to draw these to your attention so you may have a sense of what to look for in your collective agreement as well. The arbitrator observed that the collective agreement in question required that the employer pay premiums to the benefit plan, but there was no provision to pay specific benefits. The arbitrator also found that under the terms of the collective agreement, the employer could unilaterally make revisions to and deletions from the benefits program. And in addition, this was the key, the collective agreement provided that all matters relating, and I'm quoting now, relating to eligibility for or interpretation of the benefit plans shall be determined solely by the insurer. According to the arbitrator, this was clear express language that the parties did not intend for disputes about eligibility for benefits to be dealt with by an arbitrator. So two really important cases in terms of what to look for in the collective agreement when you are dealing with, frankly, not just claims for medical marijuana, but for any other claim under your benefit plan. I want to turn now and spend a couple of minutes talking about a really interesting case from Nova Scotia over the last couple of years. And this considered the question of whether the denial of benefit plan coverage of medical marijuana was discrimination on the basis of disability. And this is the case of the Canadian Elevator Industry Welfare Trust Fund and Skinner. According to the facts of the case, Mr. Skinner had been an elevator mechanic who had been very badly injured while working. As a result of his accident, he developed both a physical and a mental disability. And for almost 2 years after his accident, he struggled with different forms of treatments, narcotic and non-narcotic pain medication, as well as antidepressants, and found nothing really improved his condition. So after a couple of years of taking the more conventional drugs, he began taking medical marijuana. He sought reimbursement for the costs of that marijuana under the Health and Welfare Plan. This particular Health and Welfare Plan was administered by a board of trustees. That's why they're a party in the case. His request for reimbursement under the plan was denied on the trustees, again because medical marijuana was not an approved drug under the plan because it did not have a drug identification number. The costs of the medical marijuana were very, very significant, and as I indicated, Mr. Skinner's health and well-being had been improved with the treatment, so he subsequently filed a claim, interestingly, under the Nova Scotia Human Rights Act. He alleged that the trustees had discriminated against him on the grounds of physical and mental disability by refusing coverage for the treatment of his medical marijuana. The Nova Scotia Human Rights Commission referred his complaint to a board of inquiry for a hearing, and the board agreed with Mr. Skinner at first instance. It found that the trustees' denial of coverage for his medical marijuana was indeed discrimination, and the trustees had presented absolutely no evidence that allowing coverage for medical marijuana would amount to undue hardship in terms of increasing the cost of the plan or so forth. The trustees appealed the decision. There were a number of interveners who made submissions in the appeal of the decision as well. And earlier this year, in what is a good news decision for plan sponsors, the Nova Scotia Court of Appeal overturned the decision of the Board of Inquiry. According to the Court of Appeal, Mr. Skinner's claim was not about whether it is legal to prescribe medical marijuana or about whether Mr. Skinner needs medical marijuana. The narrow issue before the board and the Court of Appeal was whether his medical marijuana must be reimbursed under the terms of the Health and Welfare Plan, because to not do so would violate the Nova Scotia Human Rights Act. The Court of Appeal found that it did not. There was no violation of the Human Rights Act. According to the court, the trustees had an obligation to determine what benefits would be made available under the terms of the plan and what would not. In making that decision, the trustees quite simply chose to limit coverage to drugs with Health Canada approval, to drugs with a DIN. Their decision to limit coverage in that manner was not made based on a prohibited ground of discrimination. The court went on to find, very logically, that all health and welfare plans necessarily have certain limits on benefit coverage, and that it cannot be automatically discriminatory for the trustees to impose reasonable limits on reimbursable benefits. The court found, the evidence showed, that Mr. Skinner had access to all of the medications available to any other eligible plan member, and that he had experienced an adverse impact because of the welfare plan limits, simply because those medications proved not to be effective for him personally, not because he fell within a protected group under the Nova Scotia Human Rights Act. The court went on to find that if it had accepted Mr. Skinner's argument, every request for medication not covered under a plan could be subject to a human rights complaint and require justification for refusal. This would cause human rights boards to become, in the court's words, arbiters of private benefit plans. So in other words, as a result of this decision, limiting benefit plan coverage is not necessarily a form of discrimination under human rights legislation. This is, as I noted, a decision from the Nova Scotia courts. It is persuasive, though not binding on the rest of the country, though it is interesting to note that the Court of Appeal in its decision did cite a number of Ontario cases dealing with similar whether to cover medication type issues in making its decision. Quick note as well to end the discussion of this case, because it's a decision of a court of appeal, an appeal is not automatic. To appeal, Mr. Skinner would have had to seek leave to appeal the decision from the Supreme Court of Canada within 60 days of the date of the decision. Mr. Skinner's leave to appeal period expired last week, and as of Friday, when I spoke to a clerk at the Supreme Court of Canada, they had no record of an application being filed. So it looks like Skinner is the final word. The Skinner Court of Appeal decision is the final word in this case. With just a few minutes remaining, I want to make sure we give a decent amount of time for questions. I want to move on now to discuss some key considerations that plan sponsors should be thinking about in light of what we've talked about, the growing use of medical marijuana in Canada, as well as some of the cases we've just discussed. To state the obvious, it really is the obvious, but sometimes it can be overlooked. In order to determine whether or not medical marijuana is covered under the terms of your benefit plan, review the terms of the plan. Employer plan sponsors can get into trouble and have gotten into trouble in the past when they provide information on the terms of the plan to an employee without taking a second look at the plan, perhaps going by memory or a plan summary. There was an excellent case which shows what can go wrong when an employer doesn't quite understand the terms of the benefit plan from a couple of years ago in BC, and that is the case of Feldstein. In that particular case, Mr. Feldstein was interviewing with a prospective employer, and he asked a number of questions about the long-term disability plan. Mr. Feldstein suffered from a serious health condition, so LTD coverage was very important to him. Unfortunately, the prospective employer didn't actually read the terms of the benefit plan when it gave him information in response to his question. It indicated he would be eligible for a benefit when there was a certain precondition that had to be met. As you can imagine, Mr. Feldstein subsequently found him in a position where he needed to claim LTD, and when he found that the amount payable was lower than he expected, he successfully sued on the grounds of negligent misrepresentation. So I draw that case to your attention with a simple reminder that please do review the terms of your your health and welfare medical plan. And the things we would be looking for, is medical marijuana covered? If so, are there any limits on the coverage? So for example, is it subject to an annual maximum? Is coverage limited to the treatment of select conditions, or is it subject to both a maximum and limited to certain conditions? As the cases we've discussed during this webinar illustrate, a key question is often whether or not coverage under your plan is restricted to those drugs with a drug identification number, which, as you know, medical marijuana does not. Alternatively, is coverage under the plan limited to drugs requiring a prescription? If you are in a unionized environment, again, what does your collective agreement say? Look at some of the provisions that were discussed in the CIBC and the Hamilton firefighters case. So for example, does the collective agreement expressly define which expenses are eligible for reimbursement under the terms of the plan? Does it, as in the Hamilton firefighters case, restrict coverage to drugs with a DIN? Does it, as in the CIBC case, expressly defer to the insurer? So these are some of the questions to consider. If the terms of your collective agreement are vague, if they're ambiguous, what are the risks of denying coverage? Can the terms perhaps be made clear in the next round of negotiations, or a side letter to the collective agreement be entered into with the union? To end this webinar, I just want to spend a minute or two addressing those of you as plan sponsors who may have the discretion under the terms of your benefit plan to either interpret the plan or to grant exceptions. We do see more and more plans where the plan sponsor employer has the discretion to grant exceptions. And certainly beyond the scope of today's webinar to get into a full-scale discussion of what principles to consider when you have that discretion. But I just want to highlight when you are tasked with the ability to decide whether or not to provide coverage. And again, you have the discretion to make that determination. Your decision needs to be made on a reasonable and equitable basis. On the slide before you, I've referenced the approach adopted by the Ontario Workplace Safety and Insurance Appeals Tribunal in determining whether or not to authorize or refuse coverage of medical marijuana for the treatment of workplace injuries. Now, certainly this approach is not binding on a private health and welfare plan, but I do find the methodology that they adopted helpful, and you may find it instructive if, again, you have the discretion under the terms of your benefit plan. So some of the factors that the tribunal considers in determining whether or not to provide coverage is to consider whether the worker experiences constant and debilitating pain, whether the worker's doctor has recommended or prescribed medical marijuana, whether the worker has obtained the necessary authorization, whether other methods of pain control have been tried and have been proven to be less effective. And finally, one of the other conditions or one of the other circumstances considered is whether there are any circumstances which make it inappropriate for the worker to use medical marijuana, such as a history of past drug abuse. The key takeaway from this very, very brief discussion on factors to consider when exercising discretion is if you as a plan sponsor are faced with the decision as to whether or not to provide coverage for medical marijuana, and you have the discretion to make that decision under the terms of your plan, the key is a reasoned and principled approach must be made in order to reduce the risk of challenges being made to your decision. Quick final point, if your plan does not provide coverage for medical marijuana and you don't have any discretion to interpret the terms of the plan, but perhaps you're considering because you've seen other plan sponsors add the drug or you've been listening to the news media, what are some of the questions you can consider? Again, these questions really come from the cases we've discussed and some of the moves we've seen from some plan sponsors. First question, does the benefits provider you currently use offer medical marijuana as a plan option? As we've discussed, a number of Canadian insurance companies have either expressly added coverage or they've indicated they will be considering adding it on a case-by-case basis. So that's the first discussion to have. Have a discussion with your benefit plans provider. What are the potential costs to the plan? How much will your premiums increase? And if you want to add the drug, do you want to impose a dollar cap, a dosage cap, or perhaps provide coverage for only certain medical conditions? The bottom line, if I can sort of sum up the last half hour in 10 seconds or less, the key takeaway is that more and more Canadians are considering and are in fact using medical marijuana as a treatment option. So it's important that plan sponsors be ready to respond to member questions and claims for questions as well. That is the end of the formal portion of my webinar today, and I certainly welcome any questions you have at this point.
Thank you, Kim. That was a great presentation, and we're now going to move into our Q&A session. We have about 5 minutes or so, and so while we're waiting for your questions to come in through the system, and a reminder that your panel will have an ability to submit a question. I'd just like to update you on a few things that are coming up from Benefits Canada. We'll be hosting a number of upcoming events, including our Halifax Benefits on September 20th. And don't forget to enter your submissions to our annual Workplace Benefits Awards. We're accepting nominations in a number of pension and benefits related categories, and the deadline for that is June 30th. So please make sure that you take a look at our website to see if any of the categories fit for you. So I do see some questions coming through, and just in order to get started, I'll throw a question over to Kim. So you addressed this a little bit, Kim. You talked about the Nova Scotia ruling in the Skinner case. How applicable is it to the legal landscape in other provinces?
Thanks, Lynn. Yeah, I mean, I think it's persuasive. So it would certainly be looked at by a commission or by a court in another province. It isn't determinative because it is a decision from the Nova Scotia Court of Appeal, but I think it would be strongly persuasive.
And we're getting a lot of questions on the system about DINs. So with the changes to laws regarding medical cannabis in the works, would it be reasonable to expect that a DIN will be assigned?
I haven't been able to find anything that indicates the government is at least publicly thinking about that. Their focus right now seems to be on getting recreational marijuana legalized, whether moves in terms of granting a DIN to medical marijuana comes after that. It's really not clear at this point. As I said, I haven't been able to find any public statements on that from the government. If anyone on the line has heard public statements, please feel free to let us know. I would be curious.
We have a question here as well. Can you give an example of a clause that would authorize a plan sponsor to make exceptional decisions on this?
I don't know if you would actually find an express clause, as well as it's a little bit more vague in terms of the coverage that will be provided. So if there's any wiggle room or gray room in the benefit plan, that's where I find a number of our plan sponsor clients are reading that as giving them discretion to exercise their authority. Sometimes we see benefit plans that are very black and white, very clear what's covered. Other times it's not clear. And as I said, that's where we find plan sponsors are taking that upon themselves to exercise discretion.
And is there anything that you're seeing in terms of differences between public plan sponsors versus private plans? Are provincial plans looking at coverage at all?
I think every plan is to a certain degree. Some are looking at it more publicly than others. I mean, I think certainly with the Loblaw Shoppers Drug Mart announcement, there is the cynical view of that they expanded coverage because shoppers will be providing medical marijuana in their drugstores. So I think there are a lot of factors going into consideration. I do think in the unionized environment, which we would see more in the public sector, from what I can tell just anecdotally, there is a little bit more push for coverage of the drug than I do see in the private sector so far.
And what's the risk of setting a precedent by allowing exceptions in the plan?
It makes me nervous as a lawyer. Because if you allow an exception for Mr. Smith and Mrs. Jones comes by 6 months later with the same circumstance and you don't provide her with the drug, you open yourself up to the risk of a challenge. So that's why it's really important, if you are going to grant exceptions, that your reasons are you have a principled approach to making that determination, the number of factors that you consider. And it's just not ad hoc based on because, that person has a more sympathetic situation or so forth. There needs to be a principled, reasoned approach so you can put that forward more particularly to the person that you deny down the road who may have found out that someone 6 months later was granted the drug. So really important that, like I said, you have a principled and reasoned approach to exercising your discretion.
And you've talked about the human rights context and the union grievance and arbitration environment. Are there other legal avenues where this questions around coverage might arise?
I think so. I mean, I think it really just depends on how creative union counsel or member counsel are. I could see perhaps a potential breach of contract claim being made, and negligent misrepresentation we often see in the benefits world, the pensions world as well. That's why it's really important to review the terms of your plan so you're not making a promise to an employee that isn't reflected in your plan documents. Those are the claims that come to mind.
And we have a question from the attendees, a question about what about terminally ill patients and the issue of coverage in that sort of situation?
In terms of whether it's provided or whether it should be provided, or
whether there might be more of a legal obligation in that situation?
I don't know. I think it depends on the terms of your benefit plan. If we look at, I think one of the grounds of coverage that Sun Life has added as a potential coverage option under their plan is for patients requiring palliative care. We don't have that under some of the other plans that have been made public, at least, like the Shoppers Drug Mart Loblaws plan. Whether an individual could make an argument, I mean, it's possible, but the same argument could potentially be made for other life-saving drugs, right? So then we go to the whole argument as to how much does a benefit plan have to cover. It is reasonable to have caps on coverage, and all plans have caps on coverage or restrictions for certain drugs. So that kind of opens a whole can of worms as to where a plan sponsor draws the line.
And just last question before we wrap up. What kinds of policies do you suggest for use at work or during work hours? Can restrictions be put in about using during work?
That I'm going to have to defer to my labor and employment colleague. That is not specifically a pension and benefit question, but that would be more workplace type accommodation issues, workplace occupational health and safety issues. So I would absolutely defer to a labor and employment colleague or counsel on that.
Okay, great. Thanks, Kim. So that's going to wrap up our webinar. A few people have asked questions about the presentation and the recording being made available afterwards. Yes, we are planning to have that made available on our website. We're hoping to have that available this week. So you'll be able to view it and watch the presentation that way as well. So again, I'd like to thank everyone for joining us. I'd like to thank Kim for her time in putting this together. And just to note that you'll be receiving our exit survey form shortly after the webinar, and we'd love to hear your comments and feedback as it helps us to evaluate the success of these events. So thanks to everyone, and I hope you all have a great day. Take care. Bye now.